Hello and welcome to another episode of Ask Two Lawyers. I'm Keith.
And I'm Stuart.
How you doing, Stuart?
I'm good. How are you?
Doing good. Coming to everybody during this holiday week, kind of a dead week for most people in between Christmas and New Year's. And of course, we're here also with producer Eric. How you doing, Eric?
I'm doing well.
Good.
Happy holidays, everyone.
Yes, happy holidays. Well, we have some interesting news stories that I want to cover. A couple of them at first, just to go over first before we get to the questions. And one of them has to do with Luigi Mangione, the kid who's been accused of shooting the CEO for United Health in New York City.
He's the kid who did shoot the CEO for United Health. Yes.
I'm trying to do the whole allegedly thing. So,
Yes.
which you're supposed to do until somebody's convicted. But he clearly did it. Allegedly. In any event. But here's an interesting twist that nobody really saw coming. There actually is a trust and will angle to this story, which is, let's see, who was this? People Magazine posted a story, an article, that apparently Luigi's grandmother left a trust for everybody, and she had like $30 million. Like, this is a fair amount of money, although she has 10 kids and 37 grandkids, so spread over a lot of people, but still a lot of money. And one of the terms of her trust says that her grandkids can get the money, but the trustee has the right to withhold distributions if a beneficiary is, and check out this language, if they are charged, indicted, convicted of, or plead guilty to a felony. And so, and then it's, let's see, and the felony can include something that's a common law felony, a statutory felony, if it's a codification of common law, a heinous felony, a felony involving physical harm, which I think murder would be. The thing that I found interesting about this, well, two things. First of all, is that in trust documents, you can put provisions in there that allow a trustee to stop distributions if a beneficiary has certain problems. Typically, what you see is things like drug problems or financial problems, or they get into problems with creditors. I don't normally see trust provisions where, somebody is convicted of a felony. And then the other thing that's interesting about it is you don't have to be convicted of a felony. It includes being charged, indicted, convicted, or pleading guilty. So just by virtue of the fact that you've been charged with a felony is enough to trigger the provision in the trust that stops distribution. So what are your thoughts on that, Stuart?
Well, you pretty much covered it, but it's, the idea is that he was charged with a felony, and the trust language allows the trustee to suspend distributions at that time. Probably not the best crafting. It may be really what the grandmother wanted, but probably more than likely you're wanting a conviction. If there's conviction for a crime, well, now with the conviction for a crime, maybe the trustee should suspend, but the trustee should actually be paying money for legal defense if somebody is charged with a crime that they didn't do. Let's say if that is the fact scenario, well, he should be given the benefit of the doubt, which we didn't give him at the beginning of this podcast. But the thing here is that what if somebody is wrongly accused of something? There now a trustee has the ability to stop making distributions to them at a time when they probably need distributions more than ever because legal fees are very expensive. So interesting that the grandmother thought of that. That's a very specific term to add. Did she know something about her family that we don't know? Was the drafting attorney? A lot of these drafting attorneys, they include the same trust over and over again. So is this something that just got left in as boilerplate? It's interesting, but I think the trustee would have some discretion here as well. I haven't read the trust document, but it seems that they would have some discretion here. And if they have discretion, then help the guy out, get him a good lawyer, which looks like he got one of the best lawyers in New York. And let's see what happens.
You make a good point that sometimes these provisions that sound good at first, like we don't want to give money to somebody who's convicted of a felony, but they can also have unintended downside consequences, like not giving resources when somebody actually needs it. And you see that a lot in these trust provisions where it works really well in one scenario, but it works really poorly in another scenario. And somebody really hasn't sat down and thought through all the variable things that could happen in the future. But can you think of a trust that had a provision like this that stopped distributions for being convicted of a felony? Because you don't see it very often.
I've never seen it specific to convicted for a felony, but I think we both seen in our recent case of ours, it talked about just bad behavior. If a
Yeah.
beneficiary is involved in quote unquote bad behavior, well, that's a very subjective term. What is bad behavior? To one person, it might be wonderful behavior. To another person, it might be bad. So you know, if you have a very conservative trustee who has a very harsh view of the world, perhaps you would be involved in bad behavior if you were to, you know, cross the street outside of a crosswalk.
Jaywalking.
Yeah, that's bad behavior.
Right.
But so yeah, I don't like the subjective terms. Really, if you think about it, trusts are really good when you are giving all of your assets to your family in equal shares and you're being fair. Fair in the sense fair what the world thinks is fair. When you start getting exotic, that's where the problems, because there's unintended consequences to these exotic provisions that you can't fix. Well, you can fix them to some degree, but it takes court intervention, lawyer intervention. It's expensive, it's time consuming. So the more exotic you want to be, the more chances are you're going to end up in court on that issue.
Yeah, and the bad behaviors one is a great example of that. Just not good terms. Nobody knows what it means. If you kept a trust in trust until a child reaches age 25, that's different. There's a definite time, there's a goal there. But to keep it, to tell the trustee, oh, you can withhold money, you know, until they're age 25, that makes no sense whatsoever.
Here's a great question. Sorry to interrupt, but this is a question from Dawn. Thank you for joining us, Dawn. She says, and this is kind of adjacent to one of our topics that we're going to cover, but she asks, can you use selfies or videos that you upload to YouTube as your evidence in criminal court? I think she means, you know, looking at someone else's videos or someone else's YouTube channel as evidence.
Yeah, this is actually a good question, Don.
Yeah.
Thank you. I'm not a criminal lawyer, and neither is Keith, but we both deal with courts and evidence. And Keith, I get clients all the time, or prospective clients that come in and meet us and say, "Oh, I've got all this evidence, and we're going to win this case." You know, there's evidence, and then there's evidence that you can show to a jury or to a judge.
That's admissible.
That's admissible, and those are two very different things. And so, you know, it depends on what the video is. But if the video is relevant, if you can set a foundation for the video, it's somewhat easy to set foundation for videos and photos, much easier than documents. And you can say it's not a waste of the time to the judge or the jury, then chances are you could get that admitted to evidence. So if it went to, you know, if there's actually a video of somebody killing somebody, like we have in the Mangione case, that video will be shown multiple times to a jury. And then, of course, they're going to have to connect the dots to show that they believe that that was Mangione who did that by showing the way he wore his coat, the way he had a backpack on, and then they track him through. Some other examples would be, well, let's say there's a video of a husband and a wife, and they're going through a divorce, and there's a video of infidelity. Potentially, that could come into the court. Again, if it meets those certain threshold requirements, it's a little different than a statement outside of court. And that's where the hearsay rules come in. A photo is much easier to get into evidence than a statement. Would you agree with that?
Yeah, I would agree with that. And in some videos, you could have statements and they could technically be hearsay.
Yes. And if there's hearsay, then there's 28 exceptions to the
28 exceptions.
Yeah, there's quite a few exceptions to the hearsay rule, but it's not as simple, Don, as yes, you can use them. You might be able to, but we get people all the time to say, I've got all this evidence. You know, not all that evidence is going to come in at the time of trial.
But one of the big exceptions is if it's a party admission, and this is where you're big on telling clients, look, don't put things on social media when you're involved in a lawsuit, because if you put a statement out there, if you do a video, you know, who knows what it is you're saying, and you're talking about the case, you're talking about aspects of the case, that could be used against you as a party admission. Even though it technically is hearsay, there's an exception for that when it's a party admission or a declaration against interest, and you could actually find that being used against you in court. So you have to be careful what you put out there on social media. But yeah, I would say it's not 100% guaranteed that you could use a video as evidence, but there's a good chance that you could, and you just have to navigate the evidence rules to get it admitted.
You want to get to our next, topic, news story of
Yeah, because I think it's an interesting news story. It's actually a story that comes from the Wall Street Journal, and it has to do with the Montana Supreme Court case. And it raises the question of what is a will. And in this case, this gentleman took his phone and he made a video and he said, this is my will. If something happens to me, I want everything to go to my brother. And I think he actually sent that video to his brother, or somehow they had a copy of that video. And then, sure enough, a couple days later, he dies of a motorcycle accident. And the question becomes, is the video a will? Because you have a video of somebody who's clearly saying, this is what I want. He's expressing his intent for what he wants to have happen with his property after he dies. But it's not in writing. It's not a writing signed by him and two witnesses. In California, to be really a proper will, you have to have something in writing signed by the testator and two witnesses. This was just a video. So it went all the way up to the Montana Supreme Court. And how do you think the court ruled on that, Stuart?
Well, I'm assuming that they said it was not a will.
And why not?
Because it didn't meet the formalities of a will.
Which are what?
You gotta have two witnesses and it's gotta be signed.
That's exactly what the court said. And I think the same thing would have happened in California, and that is current law in California. It's really quite amazing if you think about it, that in this day and age, you cannot do a video will. Everybody's on video all the time on YouTube and TikTok and Instagram, whatever. You can say everything that you want to say on a video about what you want to happen to your estate, and it will not be enforced as a will because it simply does not meet the requirements of a will, which is it must be in a writing, signed by the testator and signed by two witnesses. And if it doesn't meet that formality, like you said, then it simply is not a will. I mean, that just blows me away.
It's civilized societies have rules, and rules, many kinds, are procedures that have to be followed, and they don't always make sense for the outcome. And so in a case like this, you're saying, look, it's clearly his intent that this be his wish to what happens with his property. But in a civilized society, we say you got to have two witnesses and a signature. And if you don't have those to begin with, we're not even going to get to whether there is a distribution that's going to go to X, Y, and Z who's named in this particular document or video or whatever that may be. You and I had a case once a very sad case where somebody had committed suicide, and they had emailed some people about what they wanted done with their body and also what they wanted done with their trust. And when they had printed that email out and they had taped it to their door, and they had put a little Post-it note on it and signed their name saying, hey, nobody come in here, because you may not want to see what's going on here. And that case actually went to trial. There, I thought the judge did a really interesting thing, because the judge knew that this is what the decedent had wanted. He wanted a change to his trust, and he wanted that followed. But it didn't meet the requirements of a trust or a will, and that is you got to have these rules that you jump through, these procedural rules that you jump through. And the court there found that the Post-it note with his name on it was the signature.
Yeah.
Would that have survived appeal? I don't know. But we won at the trial court level. The other side didn't appeal, and everybody moved on with their lives. But you could see the judge was trying to bring equities, bring fairness into that decision, because she believed that she understood what the testamentary intent of that decedent was. She wanted to follow it if she could, but it was in that gray area of, we don't have a signature. It's an email. An email going out with your name typed is not a signature.
Right.
So you need an actual signature. And here she says, well, there was a Post-it note on the email and it had a signature, so that's good enough for me.
That's a signature. It may not have been exactly on the signature line, but that's funny that the court still had to go through the kind of those backflips of, yes, but there is a signature, versus just saying, well, that's clearly what he wanted. And the interesting thing, too, is that the attorney for the decedent's brother actually says in the article, if the decedent had just taken out a pen and written his intent on a napkin, that would be an enforceable will.
Right.
Because that's the other thing, is you can have a holographic will. So if you have a will that's written in the decedent's handwriting,
100% handwriting.
100% handwriting and signed, it's a will. So if he had written something on a napkin, will. Video, no will.
Well, but my response to that lawyer, and look, I feel bad about this case because it clearly didn't capture this decedent's intent by giving to who he wanted to give to. But my response to that lawyer would be, but what are the rules? And the rules has to be, so the idea that it's a napkin, he's trying to show, if you pull out a simple napkin and do this, yes, but that's because it complies with the rules.
Yeah, right.
And there's formal rules, formality rules, and then there's substantive rules. And you got to comply with both of those sets of rules. Unfortunately, the formalities is like going to the DMV. You can't just show up and say, I don't want to fill out your paperwork. They're going to say, well, then you don't get a license,
Right.
and well, guess what? You're going
Right.
to have to fill out the paperwork.
Yeah.
And you know what? When you fill it out on the wrong line, you put your name on the wrong line, or you get the date to run over a little bit, they're going to send you back to fill out the paperwork again.
Yeah.
And you're going to go, but I've got it all there. Come on, just give me my license. No, there's rules we have that you have to comply with. And again, this does come back to civilized society. When you are in a civilized society, it is a set of rules. I mean, think about laws. Think about Congress. Every new year, states pass new laws. California probably passes more laws than any. I'm just guessing. California passes all kinds of laws.
Yeah, I had a professor that said that California never had a thought it didn't codify.
That's right. And so every year they have more thoughts. And so they where do these things? I mean, laws are just thoughts. They're just thoughts that somebody has, and they just convince enough people in the legislature to agree with them that this should become a law. And once it's blessed by the legislature, those words now have power, and it's a law. And that's what we do as a civilized society. And if you think about it, we can't just go around murdering, right? We can't just go around killing our neighbors every time we get mad at them. Why? Because that violates the rules of a civilized society. So we have rules in place that if you murder, like this Mangione, if he did in fact do it, if you murder somebody, you're going to give up your life, at least your freedom, and maybe even your life. And we're not on this right now, but I read an article, I think yesterday, that the new Trump administration, when they come in, Donald Trump apparently said he wants to put more people on death row because I guess Biden commuted a bunch of death rows.
37 out of 40.
37 out of 40. Well, again, those are just two different viewpoints of how the world should be. And I'm not suggesting one's better than the other right now. It's just that if you're a murderer, now's the time to be a murderer while Biden's in office, because you're only going to spend your life in prison rather than have it taken from you. Once Trump's in office and you commit a federal capital offense, chances are you're going to get the death penalty. So think about those things. And then, of course, it creates the whole conversation of, is the death penalty a deterrent to crime in the first place? And there's good points for it being a deterrent. And there's also good points that when people are angry and mad, they're really not thinking about, well, I'm going to be strapped to a gurney someday and given a dose of whatever, and be killed for my actions right now.
Yeah. And so you're right. I mean, laws are there for a reason. And it could come to pass at some point where maybe the California legislature decides that you could do a will by video, but I don't see that happening anytime soon. And, I think it would be a little chaotic if it was allowed to happen. And we've seen cases where people are, on their deathbed and somebody's shoving a camera in their face or a phone in their face now to take a video. And they think they're doing it because it's going to help their cause, but it actually hurts their cause because the person looks completely out of it. So I can't imagine what would happen if you could do an amendment to a trust or will by video. I think it would just be the Wild West. I don't think it's a good idea. But there are going to be cases where you also get a bad result, like this one, where that should be a will. You wish it was, it just isn't.
Yeah. This also reminds me of a time when you and I were very young lawyers. It's hard to believe we were young. And we just started practicing. And we had a client. We did a lot of estate planning back then. And we had a client that was in a skilled nursing facility, and she was on death's door. And her son was very agitated and was very worried that she didn't have her trust updated. And so we drafted her update to her trust based upon the conversation we'd had with her several weeks previous before she fell ill. So now we're running to the skilled nursing facility, you and I, and we're putting this trust in front of her. And the son grabs onto her hand and he writes her signature. And
No. He writes his signature.
Oh, did he write his signature? And I remember he was talking to us at the same time because he was just he wanted to get this done. And I remember both of us were just looking at his hand on her hand.
Yeah,
and it was just
you can't.
We can't.
There's
rules that we have to comply with. And that was what we were struggling with at the time. So I do feel bad for the Montana case because that one has to take one for the team of the idea that you have to follow these rules. But, the brother, it's very sad, obviously. He didn't get what his brother probably intended for him. And it was clear intent, but a video is not a will.
It's not going to cut it.
Yeah,
it's very sad.
I know. That is kind of a sad Montana case. I did read in the article, though. The guy has a Japanese sword collection valued at $400,000. Did you see that?
Ouch.
No, I did not.
And that's probably what the issue was then. Who gets the Japanese sword collection? Yeah.
Well, that was kind of a good segue, and I just want to, get your guys' thoughts on this, at least for a second, about this looming TikTok ban. the Supreme Court said it will take TikTok's appeal on January 10th, coming right up. We all know we got to change administration, a few days after that. But yeah, I just wanted to see, what do you guys think may happen with this? TikTok's parent company is Chinese. It's called ByteDance. And President Joe Biden signed the bill requiring them to sell to an American company or face the ban. So, yeah, what do you guys maybe see happening with this?
Well, I don't do constitutional law, but it seems like it implicates issues of constitutional law, right to free speech and just even ownership, like a taking. And it seems like we allow foreign nationals to own all sorts of other things like real estate and, Chinese companies own big commercial buildings and who knows what other interests. So I've never fully studied the subject, but I've also never fully understood why TikTok is a problem relative to anything else. I guess they're thinking that China is going to somehow subvert America through the platform of TikTok. Seems like they have plenty of other ways to do that if they wanted to, and maybe they do. But it seems like a real sticky issue. So I don't know I wouldn't surprise me if the Supreme Court does. I mean, obviously they want to step in. It wouldn't surprise me if they either block it or knock it down in the name of commerce, especially when you have a pretty conservative court looking at it. So, and if Biden's the one who passed it, you have a very conservative court in the U.S. Supreme Court looking at it, or a conservative majority. It wouldn't surprise me if it gets knocked down when the Supreme Court looks at it.
Yeah, there's obviously national there's issues with China, I think, having data on Americans, and I think that's the bigger issue. But this reminds me of the Averitt Brothers songs that people like to talk about things that they don't know about. Not to suggest you were doing.
No, that's exactly what I was doing. That's what I was trying to say.
But I was interviewing us on this right now. He would quickly leave the interview because I'm not sure how much.
And rightly so. Well, shame on him for interviewing me in the first place.
But yeah, I think there's national security issues at stake that are more than simply they have platforms that they can, infuse us with whatever it is they want to infuse us with. I think that you have a foreign company that has a lot of data on us, and I'm sure that the same is not available in China. I mean, Facebook, Google, they are very severely limited in China, and the Chinese people are limited on what they can do with those platforms. So, I think what's good for the goose is good for the gander, and free speech does have limitations, not a lot, but it does have some limitations. And I think national security would be one of those, but that's my very uneducated opinion.
So how do you think a conservative majority on the U.S. Supreme Court is going to rule on something like that?
It's interesting because the Biden administration is the one that came out with this, and Trump, he almost just goes against anything that Biden would come up with. Also, Trump has a lot of Chinese interest, but yet he's been very hard on China in the first administration. Elon Musk, I think Tesla, their largest manufacturing plant is in China, and they're planning on building more over there. So, I mean, wow, this is geopolitics at its best.
Yeah, we're all connected nowadays. So, it'll be interesting to see how it unfolds.
I still think the Avett brothers were right. So.
Oh, yeah, no, definitely. No, anybody asking me my opinion on that subject. But, the advice is worth what you pay for it. So
right. Yeah, I get that. Well, I know. I just thought it was an interesting thing. Maybe some of the listeners had some thoughts about too. But it says, through affiliates and creators and their partnerships with TikTok, they would lose $1.3 billion in their earnings in just a month of a shutdown.
Yeah, I believe that.
Yeah. So
it hurt a lot of people. I mean, there's a lot of people who rely on their income through TikTok.
Yeah. Okay, let's get to some of the questions that were gathered recently. We had a few people text the hotline, which is on the screen now too. So thank you everyone for providing your questions. Here's what we have first. Listener says, I'm told judges typically spend just 5 to 10 minutes reading each motion package, the motion, response, and reply before making a decision. In your experience, how long do you think judges spend reading filings?
I mean, I'll just jump in here, Keith. And I first want to say, and this is going to sound like I'm dodging the question to some degree. We don't have enough judges in California, and we don't have enough staff for those judges in California. We were recently at the Hawaii Tax Institute doing a presentation over there. And one of the presentations that took place before us was a panel of judges. and they were talking about how each judge on average in Los Angeles County has 900 plus cases
Per judge.
per judge.
Insane.
Uh, I don't know how they do it, and so I first want to give thanks to the court system for everything that they put up with in getting justice done here in California. With that said, I don't even know if judges can spend 5 to 10 minutes, and I'll tell you why. On a typical calendar morning, what do judges have? 30, 40 cases?
Yeah, at least.
And they spend 3 to 5 minutes with the lawyers doing the quick arguments in front of the judge on that. So I know judges rely on their or attorneys that help them
Research attorneys.
Research attorneys. I know they rely on their staff to come up with tentative rulings and to formulate decisions that they make, which they would have to do because it's just overwhelming. And to think about this, the judge will show up, do those, let's call it 30. Let's just be nice. There's 30 calendar items in the morning from a 9 o'clock calendar, which usually spills over to 10:30 to 11. By then you're almost to lunch. And then you've got a trial going on after that. And you got to pick up that trial for the next 4 hours. And that's day after day after day. It's brutal. It's brutal what judges go through. What are your thoughts?
Yeah, no, I think that's right. And I think it depends on what the filing is. So if you're talking about a motion, I mean, a typical probate calendar, especially in LA, you're probably talking easy 50 cases on calendar, but not all of them are motions. So, a lot of them are just status conferences on petitions. And so it depends on the judge. It depends on the type of filing, depends on the motion. I think there are times when judges will take more time than 5 or 10 minutes to review it. I'm sure there's times when they barely take 5 to 10 minutes because of whatever reason. But in most court systems, whether you're in San Diego, Orange County, LA, San Mateo, they do have research attorneys. They also have probate attorneys and paralegals that will review the filings. They'll make suggestions and recommendations. They'll do research, and they kind of do a workup for the judge. So that way the judge is a little bit more ahead of the game by the time they get to looking at that motion. Now, we've all had experiences as lawyers, especially because we've been doing it as long as we have, where we feel like maybe the judge didn't review everything fully and, we weren't real happy with the decision. But we've also had experiences where we feel like the judge reviewed everything very thoroughly and had a grasp of an understanding of all the issues that we were arguing. So it's a little bit of a mixed bag, but the judge's shortage in California is still quite acute. And it's amazing how much they get done with how little that they really have. And it's not just that we need more judges. We also need more court facilities, more buildings. For each judge to work through 900 and some odd cases, it's too much. And they're doing a great job with what they've got, but it's just too much.
Well, and this wasn't in the question, but one thing that really bothers me a lot, Keith, and you've heard me say this, is when you are sitting waiting for your case to be called and you happen to be the last one on calendar. It seems like you're always the last one on calendar. So it's a 2-hour calendar. When a judge asks a lawyer a pointed question and a lawyer simply doesn't respond with an answer, it drives me nuts because the judge just needs that piece of data to hopefully move this along. But instead, the lawyer says, well, and when you hear, well, back in 1970, and I wish lawyers, I'm not talking to myself too, just listen to the judge's question and answer it. The chances are they're prepared to make a ruling. And they just need, they have the report from the probate attorney or research attorney in front of them, and they just need to clarify something. I'll also say that getting a judge to go back on a tentative ruling is always one of the greatest successes you'll ever have, because there was a lot of work to get it to the point where it's at for the tentative ruling. And the tentative ruling is just basically a written decision ahead of time that tells you which way the judge is leaning. In most cases, the tentative is adopted by the court, so you kind of know that's what the decision is. But if you get a chance as a lawyer to read that and you get to hone in on, I think I could have communicated better to them about this one point, and you can take a shot at trying to persuade the judge to change that tentative ruling. And I think maybe in my entire career, I've been doing this for about 20 years now, I think I've maybe got a handful, 5 times where a judge would go back on the tentative ruling, because even then more work has to be done to undo that where they're at in that process. There is one judge in LA, I won't say his or her name, but rumor has it they've never gone back on a tentative ruling. And so everybody knows when you get the tentative, that's it. That's what it is.
Yeah, it is always fun to be able to try to overturn a tentative, but it's rare. It's very rare. The other thing that this brings to mind, though, is we had a conversation with a judge recently out of LA who really brought up the issue of case management. And I think that's the other side of this issue that is not discussed very often. And the other reason why the court system is backed up so much is that lawyers are not managing their cases to get them to resolution efficiently. And so you'll have these cases that just kind of float along in the court system. They just go on year after year after year, and nobody is like working together to say, hey, can we get this to trial? Can we get this to mediation? What's going on? Can we narrow the issues? Can we get rid of all this motion fighting? Because some of these motions are necessary, but a lot of them aren't. And that's really where the judges get a little frustrated at the lawyers, and rightly so, is that really as a lawyer, it's our job to try and increase the efficiency of the court system by managing our cases and getting them to a point where, okay, we can show up and say, we're ready for trial. We finished discovery. But that happens, so rarely. And I think a big part of it is the lawyers have to get to work. You have to concentrate on your cases, and you have to work with the other side, which seems to be getting more and more difficult as the years go by. Because I think a lot of lawyers, they conflate the idea of being a zealous advocate with being just an obstinate jerk, which gets you nowhere. I mean, you can be an obstinate jerk, and some clients think that that's who they want to hire. And that's the worst lawyer you could possibly hire, because they will not get a thing done for you. They'll just be difficult about everything. And you can't efficiently manage a case that way. You need to be competent and know what you can compromise on, what you can't compromise on. And then what you can't compromise on, that's what you're going to try. Those are the issues you're going to take to trial. But not everything. You don't have to try everything under the sun. That's ridiculous. And yet you're seeing that happen more and more often in cases, it seems like.
Yeah, you do see that a little bit more. If I had advice for myself as a younger lawyer, if I could go back in time, it would be to show up at that second or third hearing, which is usually almost a year into the case,
Yeah.
and help the judge out when they say, Mr. Albertson, what's going on with this case? Your Honor, we've completed discovery. We have one final deposition that's coming up, but we would like to have a trial date set so that we can get the case resolved. And there's nothing like a trial date to get a case resolved in mediation. And if it doesn't resolve in mediation, then it'll go to trial. So there's that. On the other point you had about civility between lawyers, it has gone down. But one thing I've noticed, you and I together, is, we are diplomats to some extent. And we are also warmongers on the other side. And that is, if we have to go to trial, we will fight the war. And we're not afraid to fight the war. And as a young lawyer, you're always afraid to go to trial. Don't be afraid to go to trial as a young lawyer. That's where you learn. That's where things start making sense after your first few trials. But don't be afraid also to be a diplomat. Don't be afraid to say, hey, I want to help resolve my client's and your client's problem here. And I understand, there's the civility where, lawyers think they're being big and bad when they, curse you out or tell you you're an idiot or give you a hard time. But what I found is people are humans. And if you reach out to another human and you give them respect and you say, hey, I want to see if we can resolve this case. How can we do that? Sometimes the clients aren't ready and you got to continue with the process. But I think we should all, as lawyers, give diplomacy much more of a chance than we do. And then if diplomacy doesn't work and you have to go to trial, you still can remain civil. One of our favorite lawyers on the planet, Bill Lowe, he's out of San Diego. I like him very much. He is the consummate professional through the entire case. I've never seen him be cross with an opposing counsel, but he is deadly at trial, and he does it in the most respectful manner ever. And I've learned so much from him and seeing him do it that way.
Yeah, no, Bill Lowe has been a huge influence on both of us, and he's so civil and professional, and yet he will completely eviscerate an expert on cross-examination. He will just completely destroy them, but he'll do it in the most civil and professional way.
Yeah.
It's a thing of beauty to watch. And I think that's what the profession is missing, is we need more of that, because diplomacy is good lawyering. And even if you don't work out a deal, that's fine. Maybe you've narrowed the issues, but you've also built a relationship so that maybe the door's open at a later time to be able to get a resolution. So there's a lot that goes into lawyering. It's not all bluster and, being a jerk. And so I think the attorneys that understand that are way more effective attorneys, and hopefully they can get their cases through the court system more efficiently than a lot of other attorneys can, where they just turns into this turning cesspool that just sits there forever.
It sounds like we should get him as a guest on the show. What do you guys think?
Man, that'd be awesome.
We'd love to. He's such a nice guy, and and he really doesn't like the glory and the spotlight. But man, if we
No.
could get him, that'd be great.
Okay, let's try. Well, hey, what about this solution? Did they ever put a window sign on the window of the courthouse and say like judges now hiring, or
No.
add in the classified section or anything?
There's a lot of judges going through or nominees going through the process. The problem is, number one, politically, the governor has to nominate somebody. You can get elected as a judge in California, but that
Very
almost
rare.
never happens. So
Yeah.
politically, the governor has to find somebody that is pleasing that will actually get appointed. On the state level. On the federal level, same thing. The president has to find somebody that's going to be able to get through the confirmation of the Senate. So there's a political aspect to it, which slows things down. And then they just don't have enough facilities. There's simply not enough courtrooms in most counties to house the judges that we need. And so it's also the second part of the problem is infrastructure. But they're constantly looking for people to put on the bench. But it's just not easy.
Well, and you got to think about the pay cut that many practicing lawyers would have to take to be a judge.
Yeah.
We pay judges quite a bit in California, but it's not as much as they will make in private practice.
Right.
We are old enough now, Keith, that we actually have a good friend who recently got on the bench. And the reason he's a good friend of ours is because we ran across him in cases when we were growing up as baby lawyers.
Yeah, really
And
good guy.
I got called by whatever the judicial council or commission is. I got called 3 separate times. Maybe it was 2 times, 2 or 3 times I got called. Basically, they wanted me to tell them everything that I knew about this guy.
Right.
And then they would even ask questions like, well, was he ever unprofessional? Did you have ever any negative experiences with this particular person? Now think about this, being a lawyer against another lawyer when
Yeah.
you're opposing each other, it's a combat sport.
Yeah, you can always think of something.
You can always think of something,
Yeah.
but this guy is a good guy, and I know he's a good guy. I know he cares for his clients, and
Yeah,
he's a
of
decent
course.
human being. And so I only had good things to say about him. And I to this day, I think when he was my opposing lawyer, he was reasonable to work with
And professional.
and professional.
Mhm.
And then when he was on the same side as us on several cases, of course, he was fine. And then we would just have lunch with him, and he was just a great guy to be around. I'm glad he's on the bench. I think he's another voice that needs to be on the bench right now, helping out that county because they're severely understaffed and underrepresented right now.
But that's a good point, though. The fire you have to walk through to even be nominated as a judge, it's a lot. And it's for good reason, but it also slows it down, and it probably eliminates people who would be perfectly good judges, but for some reason.
I'm sure you've always been very kind to your opposing lawyers. Nobody would ever have anything negative to say about you.
You can always point out something. I mean, I had a case years ago where I served a subpoena, and the attorney on the other side said that I went for the jugular by serving a subpoena.
Yeah.
Well, serving the subpoena is the most basic thing you can do in any case.
Yeah.
But for some reason, this guy thought that I was, playing dirty by serving a subpoena. So you can always ruffle somebody's feathers. And you're right, it's a full combat. This is a conflict profession.
Yeah.
You're not here to make friends.
Yeah.
So
Keith, you and I had a case against a lawyer back in 2008 or 9, and he was just awful. He was terrible. He was not a good person, in my opinion, in that case. Now, maybe he got better afterward. He was an older lawyer.
mhm.
You and I were a little bit younger. We were pretty good at that point. We were still, we knew what we were doing, but he was almost despicable to us as lawyers. And that was a long case, and the case was over back in 2009, I think, 2010. You already know this, but I got a call about 4 months ago from this lawyer, and I was speechless. I was like, why is this lawyer calling me? And he called me to apologize for his behavior back in the day. And I immediately went to, is he running for judge?
Yeah.
Or, But no,
What do
he's
you
not running
want?
for judge. But I told him, obviously after that many years, I hadn't even thought about it in some time.
Yeah.
But of course, not a big deal at all. That was just an interesting experience.
Well, especially when you're in the middle of a case, the other person can seem quite despicable when you're in that fight.
Yeah.
And then, a year goes by and you don't even think about it.
Right.
You're like, oh, that was fine. It was, whatever.
Well, if he ran for judge, I would have a different opinion, though, than I did for our friend who became a judge.
Well, yeah, that's true. Takes all kinds.
Thanks, you two. I wanted to get to a couple of these just rapid fire. You had already got to them, but I'm just going to put them on screen so, we can all know together. So, this was Brittany. She said, do clerks read the filings and summarize? And your answer was yes in this case.
Research. Yeah, they have research attorneys, they have probate attorneys, they have paralegals that prep
Right.
the filings. Yeah.
By the way, Eric, and I know this is rapid fire, but some of these probate attorneys are that I've had experience with are so good. They become well known in the community. And if you end up with this particular probate attorney reviewing your filings, you kind of cringe because they're going to catch everything that you did wrong.
Right.
But that's how, I mean, I think they really care about their job and their work. And so when you got this probate attorney, you usually had to do a supplement to make sure you cleared the probate notes.
Or you were happy because you knew that you could work with them to get something done.
Yes.
Because they also knew what they were doing to get things done too. So it's
Right.
kind of a double-edged sword in that regard.
Yep.
Okay, thanks. I understand. And then they also said, how many cases do most judges preside over? And you kind of mentioned.
Well, that
you
was
know,
LA. So we don't know what it would. I'm sure these are public statistics that are out there that people can search on Google, but LA would probably be one of the heavier caseloads, I would assume.
Yeah, and you said upwards of 500 to 1,000, or
You
that's
can
kind of a
I just
ballpark.
looked it up for 2023. They came out with a report that showed that throughout California there was something like 50,000 new probate cases filed in 2023.
Wow.
Just that one year,
Yeah.
50,000. And that doesn't include all the cases that had been filed
Yeah.
the year before that, year before that.
Thank you. And last one, I thought this was a good one. A listener says, have you ever had a judge award you sanctions? If so, what was it for, and how much did you receive? I don't know if you can mention all that, but anything come to mind?
Yeah. Yeah. Something comes to mind for me. So Keith and I were litigated against a very large firm out of Los Angeles, and they thought we were idiots, and they probably were right because we were very young lawyers at the time, but we were tenacious and we fought hard and we never gave up on that case and actually ended up for a very good result with the client. But I propounded form interrogatory 15.1 to them. And by the way, if there was only one interrogatory that you could send out in a litigated case,
That would be the one.
that would be the one, because it gives you everything. It asks for all facts, all witnesses, and all documents that pertain to the case, essentially. So you're fully prepared if they answer that interrogatory. The big firm, they basically gave us a boilerplate objection, which I had to, under California discovery rules, we have to meet and confer on that. So we met and conferred 3 or 4 times, and they basically told me I was an idiot and didn't know what I was talking about. So you and I worked on a motion to compel, and we took it in San Bernardino against this large firm. And it's funny because previously they'd had their young associate coming out. This is before Zoom appearances. This is where you had to physically appear in court. And this young associate was coming out for all the hearings up to that point in time. But when we filed that motion, they had a partner show up.
Yeah.
And the partner was there. And so I remember we won the motion, and the court said, "Okay, thank you, counsel." And I said, "Your Honor, I asked for sanctions. I asked for monetary sanctions."
Yeah.
And the judge looks at it and goes, "Oh, you did? Yes, I'm awarding sanctions." And he gave sanctions against this partner, against the law firm. The partner was there to receive it. I came back to the office and I was so excited to tell you about this. And you told me, at big firms, your experience with sanctions is what?
You have to go and report them to the managing partner, which is not a comfortable experience. It's about the last thing you want to do is go and tell the managing partner, I got sanctioned, even if it's a small amount. But I think this one was not.
It was not a small amount.
It was not a small amount. Yeah,
Yeah.
I can't remember how much it was, but it was a good amount. And it turned out you weren't an idiot.
Well, still an idiot, but an idiot with a grin.
At that time,
Yeah.
you were not an idiot.
Yeah.
But that was a discovery motion. So typically where you see sanctions are in discovery motions, but just as often you'll see a court not award sanctions.
Not so true anymore, though. Aren't we seeing a change?
More and more. You're seeing more and more judges doing that, which I think
Doing what? More judges are sanctioning, right?
are awarding sanctions,
Yes.
even if it's a relatively small amount, they're willing to award sanctions, which number one, the code said the court shall award sanctions, but the court also has the right not to if it doesn't want to, if it thinks it's fair. I think it's more appropriate to award sanctions just because I think if I were a judge, I would do that when appropriate. Just because I think that you would end up with fewer discovery motions, right? When people get sanctions, they're like, oh, maybe I should comply with the code. And that's usually where you see sanctions being awarded, is where people it's more blatant. They didn't comply with the code. There are times, though, when we won't ask for sanctions, and that's when we're going in on attorney-client privilege arguments. And the reason for that is it's very difficult for an attorney to waive attorney-client privilege without a court order. And so you really build up a lot of ill will if you go in and ask for sanctions. And that's an area where most judges will not award sanctions anyway. And if I was a judge, I'd be very reluctant to do it in that area too, because it's like, well, it's attorney-client privilege. You can't just waive the attorney-client privilege as a lawyer. You got to be very careful with that. And so I could see why you'd want a court order on that. But we are seeing more and more people award sanctions, but I don't know if sanctions are ever what you think they should be. I've gotten sanctions, various times, but they've never been as much as I felt like we should have gotten relative to the work that we put into bringing the motion or
The
whatever.
way you said that, it sounds like you got sanctions against you. So you might want to clarify.
No, I was able to get sanctions against the other side.
Okay.
But anytime I was awarded sanctions against the other side, and I never felt like it represented what we actually put into the effort.
No, that's true.
It always seems less.
That's true. I actually was sanctioned by the court one time, and it was actually my sanction.
I'm about to sanction you right now.
Yeah, you're about to sanction me right now. So I had forgotten to file a case management statement, and I was a younger lawyer, and it was a judge from San Diego, and I forget which judge it was, but I was doing a phone call appearance from our Riverside office. And so we got the hearing done. He was very pleasant during the hearing. We got everything taken care of, and he goes, "There's one other item we need to talk about, Mr. Albertson, and that is you didn't file a case management statement, and these things are very helpful for us in preparing for these hearings, and you didn't file that. It made my clerk have to go and pull the stuff from the file, and it's a lot of extra work for her. So sometimes we as lawyers don't understand what happens if we don't follow the rules, right? And the rules are that you file a case management statement before the case management conference. And so the judge said, "I'm just curious, Mr. Albertson, do you think that there's a certain number that you think that you would want to send in as a sanction for failing to do that?" And I said, "Well, Your Honor, I think $500 would be reasonable." And he says, "You know what? I think you're right. I think that's a very good sanction. So go ahead and send in $500.
Yeah.
So I sanctioned myself.
Yeah.
Of course, he was going to sanction me, so I beat him to the punch. But and I wanted to make sure that number was enough to sting, right? To make sure.
Yeah.
And to this day, I'll ask my paralegal, "Did we do the case management statement?" Because that has stuck with me through my career.
Well, we're also very careful. Like if we take a motion off calendar or something, we're also very careful to make sure we call the clerk and let them know, "Hey, we're taking this off calendar. You don't have to do the
Why do we do
workup."
that?
Because the court staff's going to put work into it. They're going to do a workup. They're going to research it. They're going to do a tentative maybe for the judge or whatever the judge's process. Not every judge does tentatives, but they still do a workup. And so just to be cognizant of the court and the court staff's time, we call and give them a heads up. And anytime we do that, they're very appreciative. And they're like, "Oh, okay, great. I'll let the judge know. We'll take this off calendar." But that's a great way to earn some good brownie points with the court staff, because they're ultimately your best friend, because they're going to help your case along when you need help filing or getting things done, not answering questions, but just kind of getting things filed and things like that. So you always want to treat the court staff with respect, and you always want to think about the work that they might be doing that they don't need to be doing. And if I'm the one causing them to not have to work, I want to let them know that.
So if Keith hasn't made the point strong enough to the more inexperienced lawyers out there, you don't want to show up to a hearing, which we see lawyers from time to time show up to, and say to a judge, "Oh yeah, I withdrew the motion, Your Honor." "Well, when did you withdraw it?" "I withdrew it 5 days ago." "Well, where's the withdrawal?" "Oh, my secretary sent that in yesterday." Because the court staff has to work that motion up. The judge has to work that motion up. And remember, they've got more work than they can handle.
Yeah.
So if you're going to withdraw a motion and you're within 10 days, say, of that hearing, in fact, if you're within any days of that hearing, but if
give them
you're,
a call.
give the clerk a call, because they will appreciate it and know that they do not have to prepare for that hearing, other than you're going to show up still because the hearing's on calendar.
Yeah. No, it's a great way to just show your respect to the court staff, and that goes a long way with them, understandably so.
Awesome. Thank you, guys. Well, that's all we had for the user generated, kind of questions and comments. Great show.
Awesome.
Yeah. Thanks, producer Eric. I appreciate it. We're glad you're back from the holiday.
Yep.
We just have New Year's to go, and then we'll be back on our regular track.
Do you have big New Year's plans? Are you going to?
I don't. No.
Okay, good.
Nothing in mind yet.
No?
So you'll still be in good shape by next Friday? You won't be like stumbling in?
Yeah, I think I'll be okay. That's the 3rd is next Friday. So
the 3rd? Okay.
We got some recovery.
Oh, so we'll be
anyways,
recovered by then?
Yeah.
We might have IVs still?
Yeah.
Yeah, just a lot of hydration. Remember to hydrate, everybody.
Right.
All right. We'll see y'all next Friday.
Yeah.
And happy New Year.
Happy New Year.
Yeah. If you heard anything and want to follow up, leave all your questions on any of our social media. The YouTube, our hotline is 858-519-8220. You can call or text. And yeah, hey guys, we'll see you next year.
next
All right.
year.
We'll see you next year. Thanks for tuning in.